Discrimination on the job isn't easy to prove, and now it just got even harder. This following a ruling from the U.S. Supreme Court. The High Court is raising the bar when it comes to discrimination cases, and that's not all. We checked with a local attorney to see what it all means from the business owner's side of view. The United States Supreme Court coming out with what some say was a victory for employers. Last year in June, the justices issued two rulings that effectively made it harder for workers to prove they suffered discrimination at their workplace.
We've seen over the past 15 years a huge spike in litigation. And the problem in the past has been that there was no means by which an employer could present its case and be dismissed at an earlier stage in the case without going all the way through trial.
Mobile lawyer Carter Hale deals with labor issues. These are the two rulings he's talking about. One narrows the definition of what constitutes a supervisor when it comes to racial and sexual harassment cases, while the other adopts a tougher standard for workers to prove retaliation for complaining about discrimination. Now, looking at the numbers, Alabama had more than 3,000 charges of discrimination in the workplace last year, a slight decrease from the 3,200 the year before. But there was an increase in the number of cases based on color and retaliation, the two areas these rulings target. Before, all the employee had to show was a mixed motive on the part of his or her employer for their termination. Say if the harassing supervisor was found to have retaliated against an employee, like demoting the person, an employer was strictly liable for that action. The standard is much higher now, and it's all to weed out what businesses consider frivolous lawsuits that can run upwards of $40,000.
It doesn't immune the employer by any means. The employer still has to present evidence of legitimate, non-discriminatory reasons why they terminated that employee, or why they made that decision, why they demoted that employee.
And he goes on to say that reports from the Equal Employment Opportunity Commission, or the EEOC, will also be taken into account, like whether there's a pattern in practice where certain employees across the board are mistreated compared to others. I've got a summary of that decision coming up on our website for you if you want to read it. It's quite detailed. It'll be up momentarily. All you have to do to look at it is log on to fox10tv.com.